So, Chair Bloom, I believe the next
A23.
A23, correct. This is a much, hopefully will not generate quite as much conversation, is a more tailored proposal to address where penalties for violations of the State Water Board's emergency water conservation regulations are deposited. Currently, under existing law, as modified last year by Senate Bill 104, one of the pieces of emergency drought legislation, if there is a violation of an emergency regulation adopted by the board during a time of drought, that can be subject to a range of different penalties. By default, those penalties are all deposited into the Water Rights Fund. Trailer Bill 823 would simply require that if it is a violation of an emergency water conservation drought regulation, this is to be distinguished from regulations that the board is adopting as emergency drought regulations designed to address its water rights functions and capabilities, then the penalties associated with the emergency conservation would continue to be deposited into the Water Rights Fund, but they would now be separately accounted for and would be available for appropriation by the legislature for water conservation. When they're deposited into the Water Rights Fund in its existing form, it has the effect of essentially increasing that fund balance, which reduces the pressures on the water right fee payers. But last year's drought legislation essentially created this new species of emergency regulation. The board could adopt the conservation regulations. So,
Mr. Loeffner, the question I have about this is that it seems to kind of muddy the waters by adding another source of funding to the Water Rights Fund at a time when if I'm not mistaken, according to our discussion on Monday, the overall legal issues surrounding the water rights funds are still being litigated in court. So how do you square that?
So to be clear, under existing law, these penalties would be deposited, whether imposed by a court or administratively by the board, into the Water Rights Fund. Essentially, all that this does at this point in time is start to separately account for penalties resulting from violations of emergency conservation requirements. And that's just to address potential commingling issues and then potentially for the legislature to identify an appropriate vehicle where those funds should go in the long term.
Are there any penalties? So let me ask that question a different way. Currently, there are penalties that are going into the fund?
There are penalties. However, to this point, there have not been any penalties associated with violations of the emergency conservation regulations the board has adopted.
But the penalties that you just referred to, when you said there are penalties, those penalties are being deposited into the Water Rights Fund?
Correct. All penalties for violations of what's known as Division 2 of the Water Code essentially go into the Water Rights Fund.
But
the emergency conservation.
Are there actual penalties that have? I want to know if there's actual dollars that have gone into the fund to this point.
Yes, but not from violations of the emergency drought conservation regulations that the State Water Board has been adopting over the last year.
And from the Water Board's perspective, what are all the potential sources of funds today before we would, if we were to enact this trailer bill language, what are all the sources of penalties, or no, excuse me, sources of any funds that could be deposited into the Water Rights Fund?
So the Water Rights Fund is primarily made up of funds paid by the water rights fee payers. Those are limited to permittees and licensees. Then there are penalty funds associated under the board's existing authorities that have gone into that account. And then the account, and I'd have to go back and consult the code, can accept some other sources of funds and transfers through the appropriate budget and legislative processes. But really, the primary source is the fee payers.
Thank you. Mr. Obernolte?
Thank you, Mr. Chair. So I understand what you're trying to accomplish here, but and I've heard you talk about what, but I haven't heard the why. Can you talk about the why a little bit?
Well, I think historically, the Water Rights Fund was solely concerned with implementing the water rights system and the permit and license program that the board oversees. Last year, through the emergency drought legislation, for the first time, essentially, the board would have authority to do conservation-based regulations that were not traditional water rights functions of the water board, not associated with permittees and licensees. And so as we get deeper into this drought, we realize we're going to be receiving, or there will be penalties associated with violating those conservation regulations, not a traditional water rights function, if you will, that would be going into this account. And it just, as a matter of prudence and sound policy, those penalties seem to be more appropriately placed elsewhere. And so this would allow for them to be separately accounted for so that the legislature could decide the ultimate place for those penalties to go.
Okay, but we don't do that with other kinds of penalty revenue. I mean, for example, when the Highway Patrol collects revenue from a speeding ticket, we don't fund driver education programs about speed. It goes to support the operations of the Highway Patrol.
It's a complicated mix across the tapestry of state and local government. I mean, some actually do go back to specific programs in education. Some, like the Water Rights Fund, the penalty is returned to the fund where it decreases the demands on fee payers. Some go back into the general fund. The legislature has made a number of policy decisions over the years in terms of where the appropriate place for those penalty funds to go
Okay,
is.
so I mean, we're in agreement on that. It's inconsistent the way that we're doing it. You're proposing changing the way that we're doing it in this case, and I'm wondering why it's appropriate in this case to change it.
I'm having a problem answering the question because I'm not sure that it's inconsistent with what the legislature has done. It's an example of the type of process the legislature has done in the past. The reason we're proposing to change it is simply we don't think this is the right fund for these types of penalties to be deposited into, and under existing law, violations of conservation regulations would go into the Water Rights Fund. And we just think that that's the wrong result. We can't think of any place where the legislature has done something quite like that.
Okay. All right. Thank you.
Any other questions? All right, let's move on to 824, drought monitoring and reporting.
Okay. Trailer Bill 824 concerns surface water diversion reporting and reporting of both the diversion quantities and the use. Under existing law, most diversions of surface water in the state of California are required to be reported to the State Water Board on either an annual or 3-year cycle, and that cycle depends on the nature of the water right. Under the existing law, there is no uniform standard for measuring the diversion of water. In other words, being able to quantify the actual amount diverted. And although people typically have to be able to describe on a monthly basis about how much water they took in a particular monthly period, there are not basic minimum standards associated with the accuracy of the diversion measurement. This lack of timely and accurate water diversion data has frustrated California's ability to respond to the drought and enforce the water rights seniority system. And specifically in that regard, for the benefit of the members, one of the difficulties we've had is, as all of you know, California has an appropriative first-in-time, first-in-rights system. And the way that that system works is in times of shortage, the most junior rights are cut off, and senior water right holders are protected and can take their amount until there isn't water available under their right, and it works backwards in time. One of the challenges that the Water Board has had this year in protecting senior water right holders and in enforcing the senior water right system is much of the data on water use is 3 years old, and there's significant concern about the quality of that data. And as we've had to issue emergency orders under the emergency drought legislation to get more refined and granular data, there have been serious questions about the efficacy and accuracy of that data. So what this proposal would do is require a baseline of annual diversion reporting to the State Water Board for all classes of water rights and specify minimum measuring accuracy for those diversions that are in excess of 10 acre-feet per year. The State Water Board, under the proposal, would be able to provide exemptions to the measuring requirements based on certain factors, including feasibility and cost. The proposal would provide authority for the State Water Board to develop measurement device regulations as emergency regulations not subject to the Administrative Procedure Act, and generally would allow the board to adopt regulations to further the reporting requirements on a permanent basis. The permanent regulations that the State Water Board presently adopts cannot be enforced directly, and in fact there's no enforcement authority for violations of most of the regulations. And so this trailer bill includes a provision that would make violations of permanent regulations adopted by the board subject to an enforcement action, and that would apply in times not only of drought but also in all times. One of the lessons that we have learned throughout this year is that the years preceding a drought are particularly important in terms of assuring the accuracy of data as well as the steps taken for conservation. And so this trailer bill proposal includes a provision to extend it beyond the times of drought so we can ensure we have good data.
Questions? Which penalties that are currently temporary is the state proposing to make permanent?
Okay, this actually would only involve penalties under Water Code Section 1846, and that allows for a $500 up to $500 penalty. It's the same factors that we were just discussing with respect to local agencies. The existing provisions of the Water Code said the Water Board considers those same factors, and that $500 penalty under existing law is available for violations of a permit or license term. Those are permits and license issued by the Water Board for water rights, as well as for violations of emergency drought regulations and orders issued by the board in times of an emergency drought. There are two other species of drought penalties that the legislature provided last year. Those two would not be touched by this proposal and would still only continue to apply during times of drought and a declaration of drought by the governor. And those are the penalties for $10,000 for a violation of a cease and desist order, or the enhanced penalties for illegal diversion, in other words, stealing of water during times of drought. This would not extend those authorities.
Mr. Gordon and Mr. Obernolte.
Yeah, thank you. I think, let me just state a position that I have. I'm comfortable with us talking about these items as in a relationship to a drought emergency. I get uncomfortable when we start talking about making something permanent through trailer bill language. Again, I think that some emergency regulations moving forward to get the data that's needed on these diversions is important, and I could certainly support that as it relates to the drought emergency. I'd rather see the permanent regulations go through a separate process than being identified here in trailer bill.
Mr. Obernolte.
Thank you, Mr. Chair. I have a little bit of concern about the specific language in the trailer bill relating to the device used to track the diversion. So if we're talking about something on the order of 10 acre-feet of water, do you know what an appropriate device would cost?
So it really depends on the nature of the diversion structure that the individual already has, or the person already has. The costs can range from about $1,500 up to $5,000 as a one-time cost. And those are for the smaller diversions, up to really, my understanding, and this is based on data that the Department of Water Resources compiled as part of their, for example, their Ag Water Management Plan process, is that figure applies pretty much between 10 acre-feet per year and I believe it's 5,000 acre-feet per year. And it's all based on whether you're talking about a lateral or a turnout in terms of the size of the diversion structure. Okay,
so if a water diverter paid $10,000, just use the middle of your range, for a device.
My understanding, just for clarity of the record, is that it is not a linear function in that.
Okay, $5,000. $5,000 using the bottom end of your range. And then next year, a slightly better device with slightly better accuracy is available. Are they required to buy another $5,000 device?
No.
Well, the trailer bill language says the measurement shall be made using the best available technologies and best professional practices. And I have my experience in local government. That kind of language has been very problematic. And so I think that we need to tighten down on that a little bit. I don't think that best available is something that people ought to be arguing when a diverter is arguing about whether or not to replace the device he bought last year.
Yeah, and that's a fair concern. I mean, we have experience both with the existing statement reporters and that best available language, which is part of the existing law, and then also over in some of our water quality authority. And it is not something that gets revisited each year. Regulations that implement them take account of new structures, or potentially if the structure is being modified and updated, you might need to revisit, much like in building code world, you would need to update to potentially modernize to address any changes in the code that had happened between then. But right now the technology is actually quite good, can be retrofitted onto existing diversion structures, and we think it can be very equitably implemented.
Okay, well, I think we're on the same page here, but I would really like to see that language changed, because if you have an accuracy standard or something that you need to be met, let's just say that, and let's not say best available.
Any other questions? We'll move on to our next, which is 825, drought water system consolidation.
So Trailer Bill 825 is designed to address a problem that the state has seen during this particular drought, and I'm sure many of you have heard repeatedly, for example, the problems suffered by the people of East Porterville, where we have a number of small systems who are incapable of routinely delivering safe water that satisfies the requirements of the Safe Drinking Water Act. One of the activities that's been identified by both independent organizations as well as the State Water Board and its predecessor, the Department of Public Health, to address these problems is to allow consolidation. And in this particular instance, the trailer bill would actually set up a process by which the State Water Board, through its drinking water permitting functions, would be able to require consolidation of local failing systems so that they could be connected with a close by community water system. There are specific findings the State Water Board would have to make before, in modifying a drinking water permit, it would require this process to be undertaken. And it would also require that the funding be available through the Water Board's programs to pay for the infrastructure to actually establish the connections between the water systems. We think this is part of ensuring both drought resilience in the future. It's very difficult for some of these smaller systems to be able to provide reliable supplies when they don't have a reliable base supply of water.
The language in this trailer bill sets up a criteria where water in a particular community is neither adequate, reliable, nor safe. Is that one collective criteria, or could a determination be made on each individual criteria?
I think the way that I read the legislation is that you would have to ensure that all of the conditions were being satisfied to make the finding. In other words, not only it would not be a matter of at one particular instance in time you can't provide safe water, but it has to be able to, the system, the local failing system is not reliably, consistently providing an adequate supply of safe water to its customers.
Well, I appreciate the fact that the way you couch that as the way you read it. Is that the Water Board's position on this?
Yes.
Okay, thank you. The second question I have is, in that definition, the word safe is used. How do we interpret that? That's
that would
fairly
be
imprecise term.
Well, the penumbra there is it complying with its safe drinking water permit that was issued pursuant to the California and federal Safe Drinking Water Acts? I mean, that's the standard for safety, and that would be the standard that would be used.
All right. Thank you. Mr. Obernolte?
Thank you, Mr. Chair. So do we have local water agencies that are refusing to consolidate?
There have been concerns expressed by local agencies. Sometimes it's the financial.
Some of them are in trouble, but it seems like our interests are aligned here. They're certainly incentivized to provide water to their customers, and this only applies in the event that they're unable to do so. So are there agencies out there that are not consolidating that ought to?
Yes, and largely the issues have to do with the agency that would absorb the failing system and whether or not they have the financial capability to take on the new connections, because often what you'll see is these systems have basic problems. It may be related to their water supply. It may be related to deferred maintenance. And so that's why part of the element of the trailer bill is to ensure that the State Water Board is providing financing, for example, for the infrastructure to connect up the systems. I mean, that is the challenge. There is a cost associated with bringing these on, and so the trailer bill attempts to address some of those concerns.
So when we say public water system here in the trailer bill language, are you talking about a municipal water system? Are you talking about an investor-owned utility, or both?
So public water system is a state of art in California's Safe Drinking Water Act, and it applies to both privately owned as well as most of them in our state happen to be public water agencies. You'll see that there is a provision that in the trailer bill, if it is a private water system, that there is flexibility, well, that the water board would have to address the fair market value as part of the consolidation. And the reality is many of these failing systems, because of their liabilities, actually don't have a positive fair market value. But regardless, if they do, that's something the State Water Board will have to address before the consolidation can be forced.
Okay. So would there be a situation that would arise where you were forcing consolidation into an investor-owned utility rather than a municipal?
It would have to be done in conjunction with the PUC. The water board and the trailer bill language would not authorize the water board to, because the PUC has exclusive provenance over them, while they still have to get their drinking water permits. All the proceeding would have to be coordinated with the PUC.
All right. I'm just a little troubled by this particular trailer bill because it seems like we're adopting a kind of a double standard. So the first trailer bill we were talking about, we are empowering and trusting local water agencies to come up with appropriate levels of fines for violation of water conservation. And in this trailer bill, we were saying we don't trust you to do the right thing because we think that there are instances where you should be consolidating where you're not. So I'll have to think about that a little bit more, but that's my concern.
Mr. Gordon.
Thank you. Can you describe for me what are the due process protections for the customers of these water systems, and would there be public hearings? How would you get to the decision to consolidate or enforce consolidation?
Yeah. So there are multiple opportunities for public process. First of all, the water board would have to confer with the local agency formation commission, which would go through a public process, presumably. And then separately, the water board would be required under the California Safe Drinking Water Act to actually hold a hearing on the permit change, which would provide an opportunity for all interested persons to participate.